Let me make sure we're good. Y'all know what to do. We are back in the building on this Friday morning. What's up, y'all? You know what to do. Drop a 1 in the chat if you can hear me. Drop a 1 in the chat if you can see me. We're going to go ahead and get into it. Welcome, y'all. Welcome back to another YouTube live stream and another episode of the ClassE Morning Show. I'm your host, ClassE Beats, of patreon.com/ClassE Beats. By the way, the link is in the description as well as in the pinned comment in the chat. We got a great show for y'all. We've got a response from UMG. UMG is out here tripping, and we're going to break down exactly what they said in their response, how it's an absolutely bad look for them, and what their message is to Drake specifically when it comes to this lawsuit. We're gonna finally get into some Karen Reed today. I know y'all are excited about that. Opening statements for the Karen Reed trial are Tuesday. The Karen Reed retrial. So let me say that a different way. So we're gonna get a little bit of background. We'll go into and look at some of the pre-trial hearing. We'll also hear what's going on with Turtle Boy. Y'all know who he is. Aiden's up in here. Got some things going on there as well. Got some updates with Tory Lanez, Brian Steele. We're gonna get into it. But before I do, I gotta say what's up to the people, man. Shout out to everybody who's in the building, and thank y'all for showing love. We up in here looking all crispy and clean on the screen. We've got my awesome, amazing Amy is in the building. Shout out to y'all. Thank you, Amy, for being here. I appreciate you. A-Fitz, Left Cleaver, Nosy Rosie's up in here. Sunwater Flows. Okay. Good morning. Good morning. We've got Trisha in here as well. Good to see you. And shout out to everyone who's in the building. Thank y'all to everyone who's liked the video so far too. I don't ask for much on this channel, but if y'all could, please make sure that you like the video. Not only is it free, it takes less than 1 second to like the video, and it really does help the channel continue to grow. Lets the algorithm know you guys are enjoying the show, and it shares the video and the channel out with more people. So if y'all could take 2 seconds to do that, I would greatly appreciate it. And we're gonna get into the show here. I will be reading super chats as we go throughout the show. So thank you to everyone who stops by, sends in super chats and supports. It means a lot to the continued growth of the channel. And I appreciate y'all for keeping the lights on here as well. All right. How are y'all feeling this Friday? What does everybody have going on this weekend? Hopefully y'all are going to get outside and enjoy. I know here in Atlanta, we've got some amazing weather. So I'm looking forward to being outside with the family. It's going to be a great time. Les Cleaver says, what a glorious TGIF it is. Nice and windy in Arkansas. It's been windy here in Atlanta too. I don't know what's up with that. Why would you put them ears back up again? Hey, y'all leave Sir Lucian Grange alone. He's just up here trying to make some money. He can't help it how he was born. Perfect Pieces in here. Good morning. Grandbabies are here to do Easter dinner. That's right. Everybody's celebrating Easter this weekend. Yep, we've got family that's going to be in town for Easter, so that's going to be a good time. Yeah, we've got a lot going on this weekend, so hopefully y'all are going to have fun. Mr. Brown is in here. Thank you for the 2-bar on my guy. Mr. Brown, always showing love and support. This man just went through a major surgery, and the first thing he could do was come back to the show and show support. So shout out to Mr. Brown. Glad you're hanging in there, putting in the work to make sure you recover well. And I appreciate you stopping by. We're still praying for you for an excellent and speedy recovery. And it's always good to see you over here in the chat. All right. Okay. I've done enough talking on that topic. We're going to go ahead and get into the show. So our first topic today, we got to talk about what's going on with Drake. So we went through and reviewed the entire lawsuit that Drake filed, or the amended lawsuit that Drake filed against UMG. And it got updated. It included a harassment charge as well in there, because he felt like he was getting harassed because UMG continued to push and push and push and use Not Like Us to defame him. So it's not only defamation, we've got harassment in there as well. We saw a couple other different changes. Most notable is that not only did Drake double down on the payola and the fact that UMG was using certain tactics to discount and push Not Like Us even more, but he actually showed and went into more of how UMG pushing this endangered him in his personal life and his family. So UMG actually responded to this shortly after the amended complaint came out. And I'm gonna be honest with y'all, I was shocked that UMG made the statement that we're about to read here. It's very telling. I think they're showing their hand in this instance when they made this statement. And we're going to talk about it here in a second. So let's go ahead and get into it and see what they said. So UMG warns Drake to be careful what you wish for in a new statement over their ongoing legal battle. What does UMG say? Drake, unquestionably one of the world's most accomplished artists and with whom we've enjoyed a 16-year successful relationship, is being misled by his legal representation into taking one absurd legal step after another. They said he's a victim. Wild. In Texas last November, his counsel instituted a legal proceeding with much fanfare and bluster. On Monday, they quietly dropped the case. Okay, is that true? In New York, in January, Drake's counsel filed a defamation lawsuit. Fearful of being sanctioned by the court for asserting false allegations, tonight they amended the complaint to withdraw them only to add more baseless allegations. The one they're talking about in Texas, the reason that got dropped, we're not going to get into today, but it's not what UMG is saying here. But y'all go, you can look and do the research for that on yourself. And I'll do another video about it at some point. They also say 2 weeks ago, his representatives celebrated a win granting of the routine discovery motion. That win will become a loss if this frivolous and reckless lawsuit is not dropped in its entirety. Oh, man. Because Drake will personally be subject to discovery as well. As the old saying goes, be careful what you wish for. UMG should have left this out, because this part of the statement to me is showing their hand. They're basically saying here, okay, fine. You guys that feel like you got to win because you're going to open up discovery. That's cool. We'll open up discovery. But just to let you know, it's going to open up discovery for Drake too. And I don't think Drake wants that. Why would they say this, or why would they imply that? The only reason I could see them saying that is, hey, if you guys want to go down this route, basically what Drake is saying, then we'll go down this route, and discovery needs to come out. Discovery will come out. Drake didn't seem to be afraid of it or worried about it at all. And if it wasn't a quote unquote win, as they're saying, then what does UMG have to worry about? If it's not a win, UMG, why are you bringing this up? Again, it shows that what's going to come out in discovery is going to tell Drake everything he needs to know. And he's been involved in the music industry for a long time. He's had a relationship with UMG for over 16 years. He knows and understands how the game is played. He knows and understands how things work behind the scenes with Spotify, with other entities, radio, YouTube, whatever. So he knows there's something there. For UMG to say this and say, oh, well, Drake, you better be careful because we're going to get discovery too. Obviously, UMG, what do y'all have to hide? I think we know by now what you have to hide. Both Texas and New York proceedings are an affront to all artists and creative expression. Should his legal representative senselessly keep the New York lawsuit alive, we will demonstrate that all remaining claims are without merit. It is shameful that these foolish and frivolous legal theatrics continue. They are reputationally and financially costly to Drake and have no chance of success. And this is a quote that UMG gave to the music business world. So I'll be interested to know what y'all think about that. We've actually got a video we're going to hear from Kanye. Kanye actually responded to what UMG said too. In my opinion, it seems like UMG is worried here. And the reason they asked for discovery to be stayed and the reason they didn't want discovery to come out is because Drake's going to be able to see and prove everything that he's been saying here. I've mentioned to y'all before, I've personally interviewed someone who is in the music industry and who showed and who told us exactly how the music industry goes about promoting different music. And we can see in this case with Kendrick Lamar, UMG went out of their way to do certain things, to make certain things happen, not only to promote a song that was doing well and the biggest hit of 2024, but to defame Drake and get a discount on his upcoming contract. Why they thought he would stand for that and just sit by and let it happen, I have no idea. Let's see what Kanye had to say on this. Y'all know he's always got something interesting to say. Let's check this out.
I'm so happy right now. You don't understand with this UMG, Drake, Kendrick situation, Super Bowl, Grammys. This shit was driving me, and you know where it should be driving me, but this is one of the biggest, if not, this is the biggest victory in music history right here. I'm never finna call Drake out of his name. I'm team Drake 100%, and team Kendrick, and team all of us. Like Kendrick need to be going at UMG at this point. This is what I said.
It could happen.
My version of like that. I said, Lucien, lifetime deal. Like, let's stop aiming all this at each other. That's all, like, bro, you have no idea. Everything is worth everything for a moment like this, where we stop going at each other and we go at the slave masters.
And it's interesting that Kanye says that, because as we pointed out in the original lawsuit and the amended lawsuit from Drake, Drake made it very clear. This is not about Kendrick Lamar. This is not about the quote unquote art. This is about UMG using a friendly fade, as Kendrick Lamar called it, right? Using a friendly fade to benefit themselves in a business way. And that's what Kanye's really trying to key in on. These two guys just wanted to go back and forth. You got the culture versus the industry, and see what happened, who won at the end, right? And it could have just been left at that. But now UMG got involved and they took things further, and they didn't have to let this song be released, first of all, because it was released under UMG. They didn't have to do the things that they did. And then it ended up hurting Drake in more ways than just losing a rap battle, which, again, Drake is gonna Drake, as we've said before. So he was always going to be the industry guy. Nothing was going to change that. Kendrick was always going to be the culture guy. But now you have UMG going out of their way to try and get a discount on Drake's next deal and make him look bad. I don't know how this is going to play out, but if this goes all the way, I think Drake is going to win this one. Not only is Drake going to win this one, I have a feeling UMG is going to have to settle too, and he's going to continue to do what he does. Or Drake is going to disappear, but I don't want to say that on live stream, even though I just did. I hope that's not the case either. Y'all let me know what you think about this in the comments and in the chat. What is going to happen moving forward? Is UMG going to settle? Is Drake going to drop this claim? We'll have to wait and see. And shout out to the gang in here. We've got over 300 of y'all in the building. Could y'all do me a favor and like the video, please? I don't ask for much. But if y'all could like the video, please, it helps us out a ton. And I would greatly appreciate it if y'all could do that. All right, let me see. What are y'all saying up in here? Shout out to CEB gang in the building. Happy Friday to everyone that's in here. Let me see what else we got. Just bought a car. I'm going to get it today. 2025 Toyota Camry, fully loaded with no sunroof. I'm blessed. Ooh, that's a, yeah. Yeah, Amy said great car. Amy loves the Camry, so it's a nice car for sure. Kanye's team is cray and make it grow. Yeah, it's hard to take Kanye seriously sometimes. I used to be a fan of Kanye and how anti-establishment he was, and how he just rose to build his own brand and his own brand and just his own way in general. And lately, man, it's been tough to be on Kanye's side, man. He's got too much going on. So I might be with you on that one, Nosy Rosie. But at the same point, I still thought it was interesting. Good morning, Ducky Dexter. Good to see you in here as well. We've got Karen here. Oh, good afternoon now. I see y'all saying good afternoon. Good to see everybody in here. Shout out to Nosy Rosie. She just became a gold member. All right, my guy Stephen G from Down Under is in the building too. Welcome to the membership side, Nosy Rosie. All right, let me go ahead and give y'all some updates on this next topic too. So let me update this. We're gonna be talking about Brian Steele. I know a lot of y'all are still upset and hurting about this, man. Some people just feel so deceived by Brian Steele. And I don't want to put Young Thug up there. Young Thug doesn't have anything to do with this. Let's get Diddy up there. So y'all may remember, we talked about this in another video. I can leave linked for y'all below. Brian Steele is going to be on Diddy's legal team. Now, why he's joining the team, I can imagine it's because not only his experience as an attorney, but his experience with RICO in general. Now, I haven't seen Brian Steele involved in a federal RICO case, so it'll be interesting to see some of the different things that he's handling throughout this trial. And we're actually going to talk about the Diddy trial in general because Diddy wants to get the trial moved. But it's official as of today. Shout out to Megan Kuna for posting this over on X. If y'all don't follow her there, make sure you do that. What does she say? Young Thug's lawyer, Brian Steele, is officially a part of Diddy's team. All right. So we've got the district judge here. What do they say? United States versus Sean Diddy Combs, order of admission pro hoc vice. The motion of Brian Steele for admission to practice pro hoc vice in the above captioned action is granted. Congratulations to Brian Steele. Applicant has declared that he is a member in good standing of the bar of the state of Georgia and that his contact information is as follows. You've got Brian Steele, the Steele Law Firm. You know him and his wife, Colette, work over there, do an amazing job. You've got the information there in his phone number. Applicant having requested admission pro hoc vice to appear for all purposes as counsel for Sean Combs, defendant in the above entitled action. I hereby order that the applicant is admitted to practice pro hoc vice in the above captioned case in the United States District Court for the Southern District of New York. All attorneys appearing before this court are subject to the local rules of this court, including the rules governing discipline of attorneys. All right, so shout out to Brian Steele. Congratulations to Diddy. He's got a heavy hitter there. It'll be interesting to see what Brian Steele does throughout all of this. Because I think seeing how the federal government is moving throughout this case with them adding some more charges to it, that there may be some chinks in the armor in their case here. Maybe this will be a part of the 2% that's actually winnable when it comes to federal cases. Y'all know the feds have a 99% success rate when it comes to getting convictions out of something that they indict. So we'll have to wait and see what happens there. But also, in some other news when it comes to Diddy, it looks like Diddy and his camp are trying to get this trial moved. It doesn't make any sense. But they're trying to move forward and ask the judge if they can get a little bit more time. Megan also says lawyers for Sean Diddy Combs asked last night to delay his federal criminal trial by 2 months. Oh, God. The judge said ahead of Friday's status conference, the parties should proceed on the current schedule. So let's see what the judge is saying here. Dear Judge, we write to update your honor regarding a request for an adjournment of the trial currently scheduled for May 5th of 2025, which is weird because they wanted things to move a little bit faster. Could it be because Brian Steele's on board now and they want to catch him or get him up to speed? I don't know, but it's strange that they would ask for a delay of 2 months. This court ordered that if the defense was considering an adjournment, to make the application within 48 hours of our conference on Monday, April 14th, 2025. And they posted this on April 16th. So they did that. As we noted for the court at the conference, counsel stated we might ask for a short 2-week adjournment. Okay, doesn't seem like a big deal. We have discussed multiple times the possibility of a 2-week adjournment with the government, which they oppose because of whatever reason that is redacted there. We spoke to the government today and have requested instead a 2-month adjournment for whatever reason, while also allowing Mr. Combs the necessary time to prepare his defense of the third superseding indictment and resolve victim 4's evidentiary issue. Okay, so we don't know. I'm not sure what victim 4's evidentiary issue is. So I'll have to look into that and give you guys an update there. Though the government has argued that to this court that the third superseding indictment is encompassed by a previous charging instrument, there is actually substantially new conduct in the third superseding indictment, which we reviewed here, about which we are continuing to receive new discovery as recently as last night. Yeah, so this makes sense. Again, we talked about the new superseding indictment. We talked about the 2 other charges that were added and we reviewed it. If y'all haven't seen that video, I'll leave a link for you in the description. Basically, they've got a couple more victims that came out and they added more of these charges of basically trafficking and flying somebody out for the use of prostitution. Let's just say it. I'm trying to use coded language. Y'all get the idea, right? So they basically want to have time to prepare a little bit more because of those 2 charges that were added. And because now they're getting more discovery when it comes to these victims. So they got that basically on the 15th and they're filing this on the 16th. Much of this discovery, which has been produced on a rolling basis since April 4th, was in the government's possession prior to the grand jury returning the 3rd superseding indictment. We note that the court has broad authority to grant such continuances where the government seeks a superseding indictment which operates to prejudice a defendant. So they need more time to prepare is basically what they're saying, and holding that the trial court has broad discretion where defense counsel needs time to investigate new allegations and discovery materials concerning additional acts. I mean, that seems pretty fair. The government opposes our proposed reasonable adjournment request, even though it is still producing discovery, including discovery on count 4, a 15-year mandatory minimum count, and is indicted over our objection that it will not produce the exhibits and witness list due today. Our additional 3,500 material, oh my gosh, while this request is pending. Under these circumstances, with discovery seemingly incomplete on a 15-year mandatory minimum count, we cannot in good conscience go to trial on the scheduled date. This is a problem that the government has created, yet it opposes our reasonable requests, and they have some redacted information there. And of course, this is signed by Diddy's attorneys. Right now, again, we have the response for the judge, and she said, hey, too bad. Y'all gotta figure it out. Dang. Pending this Friday's conference, the parties should proceed on the current schedule, including making all required disclosures. So this is directed at both sides. The judge is telling the defense, y'all got to figure it out, get it together, hire more people if you need to make this happen, while also talking to the prosecution and saying, listen, y'all were supposed to have certain pieces of information. Y'all were supposed to have the discovery to the defense by a certain date. Make sure you get that done. And then the judge says, as for the evidentiary issue pertaining to victim 4, which was first brought to the court's attention Monday, the court will also address that issue at Friday's conference. Okay. If Combs has a renewed application for that evidence that addresses some or all of the government's objections, the court will promptly consider it. So ordered by Aaron. So I'm going to need to figure out this last name, but we're going to say Aaron S. Right. The honorable judge there that is presiding over this case. So we could have possible delays based on this last statement by the judge. It's seeming like maybe if there's an evidentiary issue with that victim 4, then things may have to be delayed, especially if the prosecution isn't getting the defense what they need. Either way, Brian Steele is in there. Congratulations to Brian Steele. It'll be dope to see him back in the ring and hearing his name throughout this trial, especially as the evidence comes out. I cannot wait to see, once the evidence starts to drop, what exactly went on behind the scenes, because we got a lot of speculation, a lot of rumors, and this is definitely going to be a good one. So let me know what y'all think about this in the comments and in the chat. All right, let me see what y'all are saying up in here. And again, welcome to Gold Nosy Rosie in the building. Y'all said shout out to Brian Steele. Yeah, Brian Steele's amazing. And this happens with all prosecutors. The government held on to evidence and then added 3 new lesser charges a month before trial. We see this happen so much. And the judge tells the defense to figure it out is wild to me. We see it happen all the time. So it sounds like the defense is going to have to try to keep pushing on this. And really putting the prosecution's feet to the fire, which again, y'all have seen the trials that we've covered here. It's nothing new. In the ASAP Rocky trial, there are complaints about late discovery. In the YSL trial, I mean, that was the late discovery king trial. I mean, we had ex partes, we had Brady material. It was just rough, man. I hate that. They overcharge, then see their case falling apart, then add lesser charges. It's in the official prosecutor's playbook, it seems like, at this point. Oh man, what are you gonna do? It's good though. I think it's good that Diddy has Brian Steele on his team, because Brian Steele is not afraid to fight. He's not afraid to go before a judge. He's not afraid to go before the highest court in the nation. So shout out to Brian Steele, man. I think he's going to do a great job like he always does. All right, let's get into a little bit of Karen Reed. Let me see if I can find Karen Reed's picture up in here. And am I at the right spot? All right, there's a couple things I want to cover here with Karen Reed. There was a recent pre-trial motions hearing, so there's some back and forth about some of the witnesses. There's some back and forth about what's going to be allowed in once we get into this trial. Again, we've done a few videos on what's going on behind the scenes going into this trial. I do not want to know about anything that went on during the first trial. And the reason being is because when I cover these trials with you guys, I want to cover the trial as if I were someone on the jury. And I think we have a good time doing that. It helps us get into the mindset of what the jury might be thinking at this point, because at the end of the day, they're the ones that make the decision. And I think that's why we've been able to so accurately predict what a jury is going to decide in a lot of these cases we cover. So with that being said, now we're looking at some of the pre-trial motions hearings. We're going to see what's going on leading up to this trial, which opening statements are going to be on Tuesday. I'm excited for it, man. Opening statements are going to be Tuesday. Y'all know we're going to be here and we're going to cover the entire day of the Karen Reed trial proceedings. But enough talking for me. Let's go ahead and get into this pre-trial motions hearing and see what's going on.
Yay. All persons have any business before the Honorable Beverly County Justice of the Norfolk Superior Court and for the County of Norfolk.
Well, he's talking fast.
Give your attendance, you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Judge 22-117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves for the record?
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Adam Lally for the Commonwealth. Good morning, Your Honor.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson from the street.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms.
Good
Reed.
morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Mr. Unetti.
Good morning, Your Honor. Victoria George for Karen Reed.
Good morning, Ms. George. Good morning, Ms. Reed. All right, so I appreciate getting those lists on what we all thought were still either under advisement or needed to be heard today. There's one that it seemed that, all right, we'll start, first of all, let's start with the defendant's renewed motion that is not in writing. I think, Ms. Little, I think this was your motion for a forensically sound copy. You wanted to be heard on that?
Yes, Your Honor.
You did not file anything new, right?
No, just the motion
Okay.
for reconsideration.
When was that filed? That was filed a long time ago, right?
Yes.
Okay.
It was prior to the motion.
All right.
Your Honor, the defense respectfully requests that this court reconsider the portion of its February 18th, 2025 order denying defendant's motion to compel the production of a forensically sound copy of the Sallyport video surveillance footage from January 29th,
Interesting.
2022. The court obviously understands the importance of establishing the bona fides of the Canton Sallyport video in this case. The court sat through trial. You watched the testimony regarding the inverted video. The court initially denied the request for a forensically sound copy because I believe the court indicated it did not have an affidavit from an expert suggesting that the procedure proposed by the Commonwealth and objected to by the defense would result in the destruction of metadata. We have since provided the court with an affidavit from our expert establishing that if the Commonwealth engaged in the protocol that they proposed, namely simply dragging and dropping files from the Canton Police Department computer onto a USB drive, then all of the associated metadata would either be destroyed or otherwise unverifiable. And of course, right after we filed that affidavit, the very next morning, the Commonwealth went ahead and dragged and dropped the files from the Canton Police Department computer over
Ooh.
to a USB drive.
Okay.
That damage has been done. It can't be rectified, but there may still be some metadata and available evidence on the Canton Police Department computer that our expert can glean if that data is properly imaged. The import of this video surveillance cannot be overstated. This is a seminal issue at trial. I have conferred with our expert. I do believe that there's a chance that we may still be able to obtain some relevant information, and so we're asking that the court order this. I would also note that after the hearing on this specific issue, the Commonwealth produced a new report. That report was dated February 27th, 2025. And in that report, Canton Police Department Sergeant DGM Pietro claims for the very first time that he was responsible for downloading all of the Canton Police Department surveillance video, in this case, onto the detective drive at issue. So that's everything from January 29th. That's incredibly important. We don't have all of that information, and we're asking the court to order that that be properly imaged for our review.
Okay.
So again, this is something we just talked about in the previous segment. We've got them withholding information again. Why did they do? Well, we know why they do this. Embarrassing. Jeez.
It seems the defense characterization as forensically sound is fluid. It's difficult to follow. What is clear is that we invited them to come to the Canton Police Department, bring their expert, download anything that was on the DVR, which nothing existed, and then we further invited them to download the detective file. They had over a month to do that. They declined. That invitation has been ongoing, it's been constant, and it is current. If they would like to go to the Canton Police Department with their expert and download any of the detective file and see what exists, they're welcome to do that. So if they want a court order allowing them to come, which they don't need because we've invited them continuously, we'll agree to the court order. They're welcome to come anytime.
So is the Commonwealth now agreeing that we can forensically image the Canton Police Department detective file? Because we've been requesting
Okay,
that.
so I really don't want you talking to each other. I want you talking to me. All right, so you asked the question to me. Answer it, Mr. Brennan.
The defense cannot download the entire detective file because it contains files wholly unrelated to this case, and it would then intrude upon private information and other investigations. They can go to the detective file
here we
and they
go.
can download everything to do with this case, but they cannot have a photo image of the entire detective file of the Canton Police Department.
Okay, thank you. All right, so the next motion we're going to do is just the motion for the view. I had asked defense counsel to propose something about how Ms. Reed will get there. Have the two of you talked at all about how we're going to do our view? Two sides talked?
That's interesting.
I'm happy to do that. I don't think that it's a very lengthy conversation between the Commonwealth.
Right, but we have to make arrangements, so that was something that I asked you to figure out. You say Ms. Reed wants to go in the view. She can go in the view. How do you propose that's done?
The simplest way would be for her to...
She's going on the view?
...be transported the exact same way that they were transported last time. We were on a bus. As I stand here, I can't remember if we were not on the same bus as the jurors.
Yes, we were.
We were just separated by...
Man, yeah, this is wild, man. I mentioned this about the documentary, the ID documentary. I get she's trying to get her money, and I'm sure the View is going to pay her to be up there. But man, do y'all think this is helping her out other than money by doing this? I don't know. I'm trying to think what I would do in this situation, and I can't imagine with your life being on the line. Goodness.
Seats by distance. I don't know that would be the best protocol. I think the better practice would probably be for the defense team to arrive at the same time, follow the bus in a separate vehicle, which we can provide.
Oh, he said not the View. Oh, okay. All right. I apologize. I'm like, why is she going on the View? He said the View.
Just be there and able to observe the same circumstance that we observed last time.
All right, my bad.
So
Y'all
I'm not
disregard
going
what I
to
said.
allow all defense counsel to come in a separate vehicle, because then it will be the Commonwealth in the bus with the jurors. We need defense counsel.
Yes.
One defense counsel can go in a car then separately with Ms. Reed, and the rest will be on the bus.
That's fine.
I do need you to talk to figure out when you want to do this view. Did you want input, Mr. Brennan?
Okay, he's
The
talking
only
about the
issue
View,
that
going
was
to the
of
View.
difference was whether or not the motor vehicle would be at the address. The only reason I had reluctance, I thought it was unfairly prejudicial to the defense. If they decide
They want it, right? You want the vehicle there at the time?
We do.
if they want it there, then I'll be agreeable.
Okay.
That was my concern at the time, but if that's that request, I'll agree to it.
Okay.
The date of the view, I didn't know if the court wanted any confidentiality in the date of the view. I would like to talk to.
So why don't I see counsel at sidebar about this anyway?
Okay, so they're saying the view, like going out to the view. I completely misunderstood that. I was like, why? What are we doing? All right, they've got a little bit of a sidebar, so we'll skip back ahead here.
All right, so on the defendant's list, I don't understand the motion regarding Dr. Welcher, because that's been decided. So why is that here on this list? Is it erroneously on the list?
It's not erroneously, Your Honor, but Mr. Brennan and I spoke about it. We have an agreement that will obviate the need for the court, which is my presumption. Mr. Brennan is going to state it, and that would be my suggestion to Your Honor, and then we can move on to the next matter. We've reached agreement.
Okay, what's the agreement? What's the agreement?
The agreement is there's going to be a redaction to the PowerPoint presentation of Dr. Welcher, specifically page 37. There was, according to Attorney Brennan, an erroneous remnant on 37.
Okay, so why don't you just provide me with the new slide so I know what it is, okay?
I will do that.
All right, thank
Thank
you.
you, Your Honor.
Okay.
Judge Bed moving right
So-
through.
Lieutenant Wing, docket 607 and 658. So what I want to
She'd
know
be up
about
there
that,
breathing
Mr. Brennan,
hard.
before we begin is, do you have the new report of Lieutenant Wing?
I do. I received it last night. I haven't read it, but I discussed it with counsel. I understand it's just minor edits to the original report, so that won't delay any hearing on this.
All right, so you're prepared to go forward?
I am.
All right, I'll hear you.
Lieutenant Wing is the dog bite
Your Honor,
guy.
the defense
Yeah, so-
proposes Mr. Wing as a dog bite expert.
Okay.
I think it is too late to ask for a Lanigan hearing. The trial's upon us, regardless of whether or not I think I have standing for it. I do not want to delay this trial in any way. However, there are concerns about the qualifications of Mr. Wing. He has no experience in pattern recognition analysis. I see no training on his resume. I will not hold the defense to the standard they've tried to employ, that he is not a medical expert, nor will I rely on Dr. Russell saying she's the only qualified individual in the country, but rather this person should have some qualification to come into court and give an opinion that a abrasion is supposedly a dog bite. It doesn't appear that Mr. Wing is a certified trainer. It doesn't appear that Mr. Wing has ever testified in court before. And so to expedite the matter, rather than look or seek a Lanigan hearing, I think it would be helpful to have a short voir dire regarding his qualifications before he's presented as a witness, so the court can determine whether or not he is in fact even a qualified witness in this case.
Thank you, Your Honor.
We'll put him up there
With
and grill him
regard
then.
to the report, I just want to underscore that there are changes to, and I discussed these with Attorney Brennan, but I want the record to be clear. There was an objection to the original report of references to Dr. Crosby. We removed those, so those are fairly substantial.
Are there any other changes to it other than the removal of Dr. Crosby?
There are, but there, as Attorney Brennan indicated, they're minor parlance, et cetera, but otherwise it's the same substance.
Okay. So why don't you provide me with the new or redacted one as well, and I'll take a look at it.
Right, that has, I will do that, Your Honor. I'll provide the court with that forthwith. The second is on the substance. Lieutenant Wing is extraordinarily experienced. You will see that in his report. The
Jeez.
summary of his experience, because it would take a lot of time to go through it. For several years, he's been one of, if not the country's leading experts on training law enforcement with regard to the use of canines, not only with bite and hold techniques, but also with what are called washout dogs, which are very much similar to civilian, some call them pet dogs. He has
Interesting.
extraordinary experience with wound recognition, Attorney Brennan respectfully is incorrect when he says he doesn't have experience with pattern recognition. His experience is extraordinary in that regard. Your Honor will make her own judgment,
Okay.
but the report clearly establishes his pattern recognition. His methodology, unlike that of Dr. Crosby, is stated in his report, and in addition, he cites 2 specific studies for his report, including pattern recognition, and the whole topic of pattern
Sounds like it should be
recognition
fine.
was well established through Dr. Russell, so Your Honor will see that as well. My last category of points to make, Your Honor, is this. The timing of this report came in light of the court's ruling on Dr. Crosby that a non-medical doctor can opine on wounds to humans. And we did make a motion for reconsideration with regard to Dr. Crosby, and understanding the court's schedule and other matters, given that there was not an ability to have that motion determined, we then decided that we had to submit the report of Lieutenant Wing. We want to make clear that Lieutenant Wing is being offered not as a rebuttal, but as part of the defense's case in chief. And it is part of that in light of the March 6th order of the court with regard to Dr. Crosby. The aspects of behavior in combination with a wound recognition is different from Dr. Russell. There is overlap, but it's different. And the bottom line here is that the approach of Lieutenant Wing and his qualifications exceed that of Dr. Crosby. And my request, Your Honor, is I do not believe there is at all a need for any kind of a hearing. Again, Your Honor will make that judgment when the court believes that, notwithstanding the qualifications of Lieutenant Wing and his methodology as set forth in his report, we would respectfully request that we have a voir dire hearing on Dr. Crosby. We have made that request of Dr. Crosby.
That's another motion. That's what we're going to hear now.
Understood. And I was just going to say, I am not going to get into the basis for that. I just wanted to.
Sorry, y'all. This is not me. It's the feed. I guess at some point it was glitchy.
Just go ahead. Just move on.
Yeah. So my request would be that a determination on whether or not there's a voir dire of Lieutenant Wing abide the motion in the discussion. So in conclusion, Your Honor, we respectfully request that have a voir dire hearing on, at a minimum, wait for that determination until the court reads the report of Lieutenant Wing.
Right.
Thank you, Your Honor.
Okay. All right. So there's also
I don't know,
a
Jonah.
motion for reconsideration regarding Dr. Crosby. I can tell you regarding reconsideration, I've found that he is an expert. I am not going to reconsider whether or not Dr. Crosby is an expert. I'm not going to reconsider whether he can testify as something is consistent or inconsistent with dog bites.
Okay, there you go.
But Mr. Brennan, I don't see how you're going to have him testify as to whether these marks could have come from Chloe, the specific dog. I think that you can certainly talk about measurements that may have been made, but I don't see how he can testify that this either was or was not this particular dog, particularly in light of the most recent National Academy of Science report that found that no evidence of an existing scientific basis for identifying an individual to the exclusion of all others via bite mark evidence. So,
I mean, that's a great point that she makes. Is every dog bite the same? I mean, are there slight differences or variations? I mean, maybe if the dog had, a teeth that was going a certain direction, that you could see that. But yeah, I got to agree with Judge Bev on this one. That might be hard to prove.
What do you want to say about that?
Your Honor, there's a distinct difference between inclusion and exclusion. The National Academy of Forensic Science was an extraordinary study, well respected. I've read it many times, and that is a consensus among experts that teeth structure can in many ways be similar, so it is unfair to conclude that a particular person or a particular dog should be included or identified as the person who left that particular pattern. I agree with that wholeheartedly. It is different in kind and not within the realm of that study or any other studies that I've seen to exclude a person or a dog as the contributor of that bite. And here, there is definitive evidence to clearly show and base an opinion that the dog named Chloe was not the cause of those wounds. That is the whole purpose of having the mold of Chloe, which is done with humans routinely, often, orthodontists, dentists, restructuring. The spacing itself is so distinguishable between the molds and the spacing on Mr. O'Keefe's arm. It is an objective, a specific, and a substantive basis to draw a conclusion that there is no way, to a degree of certainty, that these wounds were caused by Chloe's mouth. In particular, Dr. Russell had opined not only that the bites were consistent with a dog wound, but she also opined about molars in different parts of the mouth. And
Right.
since the
That makes
defense
sense.
has decided to likely identify particular teeth and structures as the basis to say it's comparable, consistent with a dog, we should be able to counter that in rebuttal, not in our case in chief, in rebuttal, that these molds show to a reasonable degree of certainty that these wounds could not have been caused by Chloe. So it's exclusion, not inclusion.
It's an uphill battle for you, I'll tell you that. I'll hear from Mr. Alessi.
Dang. She said good luck with that one. Okay.
Thank you, Your Honor. I can go through this quickly. The National Academy of Science, the 2009 report Your Honor is referring to, there is no finding in that exclusion's okay, but inclusion is not. There's nothing in there to support that proposition. That's number one. Number two, with regard to the opinion of Dr. Crosby, he did use a mold, but he didn't use the overlay. In the NAS, I'll shortcut it, 2009, the only way you even get to discuss it is you have to have the mold and the overlay. Dr. Crosby doesn't have the overlay. So even not considering the first point I made, where that's allowed for humans, you need a mold and an overlay. So there is no basis in science for the proposition that with certainty this could not be Chloe. So in sum, the inclusion-exclusion distinction that Mr. Brennan tries to make is nowhere rooted in the NAS study. And the point that Your Honor made and that we have made consistently is that there's little difference between inclusion and exclusion when you get to the methodology that's employed. So we, Your Honor, would support what Your Honor's comment was in the beginning, and that is there should be no discussion with regard to Chloe on inclusion or exclusion basis. Thank you, Your Honor.
Did you want to reply?
Yeah, the judge isn't really feeling it either way, so the prosecution has to be careful here.
I would simply suggest that there is no authority that I'm aware of that prohibits exclusion, none. And as a predicate, and I know it's a side matter, the idea of Chloe, as a predicate, that requires third-party culprit. And so before there can even be discussion about that, there would have to be an offer of proof that we have not seen and has not been presented. So it really should be irrelevant. But if the defense is going to try to bring it up, it's going to become a live issue. And if we have an obligation or we have a need to rebut, we want to fully rebut any of those claims.
Okay, which is why originally I was going to hear this motion to reconsider after the defense presented their witnesses. So, all right, thank you. The
Why don't y'all
substitute
like Bev again?
chemist, is there any objection to the substitute chemist? It's Commonwealth's motion 663.
No, Your Honor.
Okay, so Jim, 63 is allowed.
Yes, Your Honor.
So you both have motions that are similar regarding, it's the Commonwealth 669 and Defense 670, I believe. It's about the audio-visual aids and giving notice. So you're both in agreement to give notice to the other side before you use anything, and have you done so with regard to openings?
The Commonwealth agrees to give notice.
Yeah,
We
she's being good
provided
today.
A number of clips of statements that we seek to use during the trial. I hope to narrow the ones that we're going to use specifically so the defense could have more notice of it. We have a clip that we'd like to offer in the opening. I'm not sure if our office has provided that to the defense. If not, we'll do that shortly after the hearing.
Okay. Who's arguing this for the defense, or who's telling me what's going
Your
on?
Honor, we're happy to provide notice. We have not yet received the particular audio clip that the Commonwealth intends to use during opening, but we're happy to provide any visual aids that we intend to use as soon as today.
All right.
Okay.
I'd like to see what you both intend to use in your openings, because whether you agree with it or not, I have to make sure that it's admissible, that I know it will be coming into evidence before I let you put it up there.
That really is the
This is
motion.
for the court. The Commonwealth will provide a copy to defense. That's
Okay, thank you. Can I have the defense what you intend to put up?
This single photograph, Your Honor. I'll provide it to the court immediately after the hearing.
Okay.
Your Honor, I'll add that there are a number of statements that we have clipped. We, with the court's permission, would like to provide an entire package to the court so you can have an opportunity to view if you want.
Oh dang, they're gonna have a whole slideshow for y'all.
So I need
During
the
opening.
defense to look at this before the end of the hearing, because I don't want to bring everybody back tomorrow if you object to what the Commonwealth intends to put in their opening. Did you tell them what it is? Like, is it something that they already have?
They've had the materials, the interviews in total, but we've clipped the pieces that we want.
So
It's been
no.
an ongoing process. I understand my office has sent a slew of those clips to the defense.
Okay.
I want to narrow it down. We're not going to use all of them unless there's a rebuttal portion, but I want to narrow down what we're giving them.
And y'all know how clipping goes, right? We saw this in the ASAP Rocky trial, and Joe was like, "Oh no." They clipped up that video where ASAP Rocky was going back and forth with Relly, showed things in a certain way. So no, if you clipped it up, we need to see what you're planning on showing, because it could paint things in a different light. Come on, y'all. We've been through this.
We've been over-inclusive in what we intend to provide.
The Commonwealth
Over-inclusive.
provided at least 44 clips. I'd ask for whatever they intend to actually use in their opening so we can look at it for.
I think that's what they just said. They're just going to
yes,
give
we'll
you.
give them the file name and if the court takes a recess, we'll
Yeah.
give them the file
Yes,
name.
I'd like to do that just
Good
in
job
case
by
there's an
the
objection.
defense.
Or I can bring you all back tomorrow or Friday, and I don't really want to do that to you. So, all right, so we'll just take a look at that. Okay, so that sort of also covers, I guess, the
That's a good call out
defendant's-
by the
I'm sorry,
defense.
the Commonwealth's motion regarding the use of extrajudicial statements. And if you hang on while I grab that. Is there an objection to that motion?
No, Your Honor.
Okay.
Can I make a note?
Yes, please.
The defense, I'm sure, is aware, but I want to point out as part of that motion, we're asking to have an independent reader, someone who is not an officer or involved in this case. I don't expect there'll be any emphasis or drama in the presentation of text messages, but I think an independent reader is fairer, more objective, and we'd like to have that independent reader take the stand at times throughout the case when we want to introduce certain text messages that don't involve a participant.
All right. How are you going to find this person?
But we could
That's a
have
great
somebody
question.
playing close from the state police, or we could find somebody that's agreeable to the defense. But I think it would be best if we have an independent reader who's available throughout the trial to play that
Hey,
role.
y'all, I'll do it. Hey, fly me out there. Y'all, can somebody reach out to the prosecution and let them know I'll do it if they want to fly me out there to read text messages? I don't know what's going on here. I believe innocent until proven guilty, but I'm not biased when it comes to the Karen Reed trial, looking at this as it's being presented in this retrial. So, hey, y'all fly me out there. I'll read the text messages. I might add a little bit of, sauce on them, but other than that, I'll do it.
Okay.
May I have a moment, Your Honor?
Yes.
They're arguing over nothing. It's not that complicated, man. All right, we're gonna.
My colleagues,
Here we go.
Your Honor, thank you for the time to consult with my colleagues. I don't think we're in a position to agree or disagree at this point. I don't know exactly which text messages or which conversations are intended to be independently read. At the last trial, they simply came in through the person that found the text messages. They were, Mr. Lally asked, I think, Mr. Carino, I can't remember his first name.
Derek said, "You're going to walk into
to
the courtroom and they're going to say,
recite
wasn't you
messages from both
streaming
sides.
this morning about that
was done
trial?"
Pretty effectively and
Don't worry about
expeditiously. But unless I know more about exactly what the theater of having
It's my
an
twin
independent reader
brother,
is going
Derek.
to be like, I can't really weigh in.
Go ahead.
May I?
Yes.
Wherever there's a witness involved in the conversation, if those text messages are admissible, it would come in through the witness. Text messages between Mr. O'Keefe and the defendant, there is no author of those. And so we will introduce those text messages, the admissible ones, at different parts in the trial when they become relevant. So it's not sufficient to simply have a state police officer who was not a witness to those text messages to come in
and read them continuously through the trial.
Just let
Mr.
me do
Guarino
it, y'all.
is
I
an
got y'all.
independent witness in this case. To bring him back regularly as a police officer, I think is creates the wrong impression. I think objectively we can have somebody come in who simply reads those text messages when they're appropriate to introduce.
You know what this tells me about those text messages? Those things are spicy. I can't wait to see once we get to the text messages, because if there's this much, if they have a whole motion about getting these text messages read by the right person, there was some word being said in these things, but hey, they're Bostonians. Not surprised.
I would disagree gently with Mr. Brennan. That's exactly what the proper protocol is. If Mr. Guarino is the one who found, he's a state trooper, he found the text messages. He was the one who downloaded the data. He was asked about those text messages previously. I think having him come back, and
I said
no
I'll
matter
read
how
it.
many times he comes back, he's paid by the state. He can come back 5 times or 1 time. But to have somebody else come in, or other individuals come in to act as readers, I think that is not in keeping with the ordinary course of presentation of the evidence. It just doesn't make sense to me to have a reader come in. It seems to add a theater to the text messages that are inappropriate. I don't know who these individuals would be, and the text messages are admissible because they're statement of a party opponent, and the other is the context of the statement of the party opponent. So I don't see any reason to change the protocol that we had last time.
All right. If I were to allow an independent reader, do you have a male and a female? Or would it be a male reading a female's responses?
I haven't
Let me read
identified
it, Judge
anybody
Bell.
that I can get a male and a female.
All right.
And that's exactly what we don't want. I think that's inappropriate. It's not going to be Mr. O'Keefe, and it's not going to be Ms. Reed. The text messages speak for themselves. The jurors should be able to analyze the words that are on the page, the text messages as they were written and drafted, not the inflections and the repartee between 2 independent people with motives that may or may not be consistent with the text messages. As we all know, it's a very, very different circumstance to have a text message communication with someone and have a conversation with someone, for instance, telephonically or verbally. People talk about it all the time. Things get lost in text messages.
They
Having
sure
them
do.
read by a state trooper who found them.
So it can be perhaps not a state trooper. That's all. I understood it to be to take out all infliction and completely that.
Right. I heard Mr. Brennan say the same thing. I don't know that that's actually what's going to happen. And this lends
just
itself
object.
to sort of a theatrical presentation that's completely unnecessary and could be incredibly
Damaging.
objectionable. And then once it's done, it's done.
All right. I will consider it.
Yeah, I'll go up there and I'll be like, this is Karen Reed. So, you were with that girl again last night? John says, no, you crazy bitch. I don't know what you're talking about. Karen Reed says, you wait until I come up there and I'm... I can do it. Judge Bell, let me do it. I'll do it. No inflections.
Thank you. All right. Defendant's motion for specific discovery, paper 638.
I'll probably laugh, though. I'll probably be like, give me a second.
All right. Who's arguing it?
1 second.
Yes, that's me.
We got to get it together.
Good morning. Before court today, Mr. Brennan and I conferred, and I think we've largely reached agreement. The only numbered items on which we do not agree are 3 and 4, which are related. I will say,
You wait until I come
as a
up there.
preface,
I'm
that we
going to
are
whoop your
withdrawing
ass.
Request number 8. And with regard to request number 7, we've agreed on the following language, Judge, which I would read into the record. Number 7 would be any indication of a witness willing to change testimony in exchange for any consideration. With that,
Say what now?
I would ask the court to allow the motion. With regard to 3 and 4, I believe that we should receive information if there's a witness who has expressed to the Commonwealth either a refusal or a reluctance to testify in this matter or to cooperate in any way.
Okay. There's no authority for that in Rule 14, correct?
We believe that it's consistent with Rule 14, which is why we've made the request.
Okay. Where? Where in Rule 14 or the reporter's notes?
Relevant and discoverable. It applies to a witness's credibility, motives, intent, and that's the basis on which we make the request.
Okay. I'll hear from the Commonwealth.
Number 5? Yes. With regard to number 5, we also talked about modifying the language. Mr. Brennan had taken it down for us. Any information of any witness regarding promises, inducements, or rewards to that witness.
Okay. Mr. Brennan, regarding 3 and 4, what's the Commonwealth's position?
Your Honor, that does not go to motive or credibility. It is not within Rule 14, should not be discoverable, it's irrelevant. It doesn't show any bias on behalf of the witness if they had any reluctance or concerns about testifying. I have been very broad in my agreement regarding discovery. Anything that is Rule 14, exculpatory, even their specific requests which extend beyond Rule 14, I am more than happy to give them, but I think 3 and 4 are personal, irrelevant, and have nothing to do with bias or credibility.
Okay, thank you. All right. The ARCA witnesses, motions regarding that. So where do you stand, Mr. Brennan, with what has been provided and what you might think has not been provided?
There are 2 issues. There is the discovery that we have requested in the past. At this point, I stand unsatisfied with that discovery production. And then secondly, there is the limitations that should be imposed upon ARCA based on what has been provided pursuant to reciprocal discovery.
What's ARCA?
I'd like to start with the second part, and that is we have a little chronology. December 5th, 2024, we submitted docket 442, Commonwealth's motion for reciprocal discovery, which was allowed by the court. There were a number of other motions which led to March 27, 2025, docket 640, Commonwealth's motion to compel reciprocal discovery of ARCA witnesses or to exclude their testimony. And then the next day, on March 28, 2025, the defense responded with docket 642, which was a response to docket 442.
ARCA LLC is a multidisciplinary engineering consulting firm specializing in accident reconstruction and forensic analysis. ARCA's experts Daniel Wolf and Andrew Rentschler are playing a pivotal role in Karen Reed's defense by testifying that the injuries sustained by the Boston police officer John O'Keefe were inconsistent with being struck by a vehicle, and that the damage to Reed's SUV did not align with such an incident. This is why the prosecution doesn't like him. Got it.
And so what we were looking for, not only Rule 14, but more specifically our discovery motion, was information from ARCA that would make clear the relationship between the ARCA witnesses and the defense.
And it gets more interesting. Initially, these experts were presented as independent witnesses during the first trial. However, it later emerged that they had been compensated by Reed's defense team, leading to allegations of potential bias and concerns over the transparency of their involvement. Oh, man. The revelation prompted the prosecution to accuse the defense of engaging in a trial by ambush, suggesting that the defense failed to disclose the full intent of their relationship with ARCA. In response to the concerns, Judge Beverly mandated, oh man, we're going to talk about it here in a second. Mandated that Reed's defense team disclose all communications, contracts, and payments arranged with ARCA by April 18th, which is today. So additionally, the defense team was required to inform the prosecution by April 21st if of any planned further testing involving ARCA. These measures aim to ensure transparency and fairness in the upcoming retrial, where opening statements are scheduled to begin on Tuesday. There we go.
From its inception. It is important because that information, a thorough vetting of the information, may be a basis for the Commonwealth to inquire of these ARCA witnesses, if they're called, about candor, truthfulness, and full disclosure. And so while we've received some answers to our questions, we want a full vetting of that history. On a prior date, the court suggested that perhaps we could have a voir dire, not regarding their qualifications, but regarding this very issue about the relationship between the witnesses and the defense. That is one viable option. My concern specifically is if they are subject to a voir dire the day before their testimony, they're traveling from out of state,
they will not have with them documents and other items which are necessary for the Commonwealth's review and likely use during the examination. And so if the court was to maintain there would be a voir dire the day before the hearing, I would ask for an order from the court to order ARCA to bring the discovery that was ordered in the Commonwealth's discovery motion back on December 5th, 2024. The response by the defense, a large part of it is that it's not within their custody or control. And so these items, I expect, would be in the custody and control of these ARCA witnesses. There are a number of specific items which we sought in our discovery motions. Those items include communications, billing, emails, text messages, etc. And so those documents, if we do not obtain them in advance or the day before the witnesses are set to testify, we will never have an opportunity to send them home to get the materials that are relevant. So if the defense position is not in their custody and control, then I ask the court to order the ARCA witnesses to provide that information prior to the voir dire so that we can review it. Secondly, the defense has provided that they have retained the ARCA witnesses independently. We have received no new discovery other than communications and emails. What is concerning is that in the notice from the defense, there is some suggestion about the ARCA witnesses potentially rebutting or commenting on Mr. Welch's testimony. Discovery deadlines have passed some time ago. It would be inappropriate at this point to have any new opinions, any new information, any new reports.
Here's what we just talked about.
We have been steadfast from the beginning of this case, early on, about discovery deadlines. And so my expectation is if the ARCA witnesses testify, they would be required to testify pursuant to their February 12, 2024 report, and they would not be able to provide any further opinions, any further ideas, or any further reports. So the two things, to simplify it, that I'm looking for is for the court to have that voir dire, again for a limited purpose, to order ARCA witnesses to comply with the discovery order that the court has already imposed, and to have ARCA limited to the discovery that was properly provided before the discovery deadlines. Those are my three requests.
It seems pretty fair.
I want to go in reverse order briefly, if I could. Concerning the discovery deadlines, we have continued to receive new notices of discovery from the Commonwealth well after the same deadlines that Mr. Brennan is now bringing up concerning ARCA. They filed their notice of completion or certificate of completion long ago, and we have consistently received new information from their experts, new reports, amended reports, redacted reports, additional information. Both sides understand that discovery is an ongoing situation, sometimes out of our control. To that point, on March 26, 2025, we received for the first time official notice from the United States Attorney's Office of the Department of Justice that we, the defense, or either side, the Commonwealth as well, were free to engage ARCA directly as expert witnesses in this case. On that same day, we contacted the Commonwealth. Actually, the very next day, we contacted the Commonwealth and provided them information that we would be and had engaged them. We've provided the engagement agreement. We've provided them with all discovery that we have appropriate thereto. And insofar as, or to the extent that any additional testing and or analysis is completed by those experts, because keep in mind, it's only been, we can count it in days that we've actually been able to engage them. If there is in fact additional testing and or analysis that is noteworthy, then we will, or that we intend to use, we will obviously provide that to the Commonwealth forthwith, which we indicated in our moving papers. We will maintain that posture throughout. And if there is additional information to be disclosed, it will be disclosed. It will be disclosed in a timely manner. We do not have anything as yet as we stand here today, but we...
What do you think a timely manner is? What ballpark are you talking?
When I get a report, I will turn it over the same day. If I get a report, I will turn it over the same day. If I get a new analysis, I will turn it over the same day. If we get new testing results, we will turn those over the same day that we get them. In other words, I can't control the conduct of the experts.
Right.
They may or may not be engaging in additional testing or analysis, but if they are, once they get it, we'll turn it over.
Seems pretty
all I can say to
straightforward.
that. We're not holding anything back. We're not hiding anything. We're, as soon as we get something, if we get it, to the extent that there is additional analysis or testing done, that will be turned over forthwith. With regard to docket number 642, we did, Your Honor, I don't want to waste the court's time. We did respond in detail to every single one of the 12 requests that the Commonwealth has made. I'm happy to go through those if the court wishes me to, but
Hold on one second. Mr. Brennan, are there specifics that you say are still outstanding of the 13 or however many points there were? Because this is on what you filed, so this is not unusual. A party says, we asked for all 13, another party says, we gave them to you, and then the party says, I don't have them. Can we narrow this? Is there anything specifically that Mr. Jackson should address?
Yes. Their response is that it's not in their custody or control.
So for which ones? Which of your numbers?
What do you need, man?
Number one, a complete statement of all opinions to be expressed by Daniel Wolf.
Okay.
And their response is the information
we just talked about Daniel Wolf.
Defense has already been produced. That obviously understates the fact that they would hope to have new opinions. That is the very point that this is not responsive. Their discovery deadline has passed. And so I would like to talk about or respond after Attorney Jackson is done about what is going to evolve from this conversation. This is exactly what I was worried about back in November, what I expected might happen and should not have happened. So it's difficult now to parse the different pieces of my discovery request, but we do not have all the billing, all the communications, all the text messages, all the emails between the parties. And if the defense's position is not in their custody control, well, it's certainly in the custody control of ARCA. We do not have all prior reports, all prior testing, all field testing, photographs, pictures. We don't even know who was what part of this report.
Okay.
And so my tolerance about this ongoing development of discovery is a extraordinary problem for me. This is the number one issue I anticipated and that I've tried to prevent.
Okay. So address number one, Mr.
the
Jackson.
number one issue that Mr. Brennan has anticipated and tried to prevent is ARCA testifying. Let's just call it like it is. They
So
desperately
address
does
number
not
one,
want-
please.
I
Okay.
am. That's what I'm doing, Your Honor. We have provided on April 12th about 1,000 pages, additional pages, responsive to the request specific to ARCA. The response that we provided to request number one is as follows. The information in the possession, custody, and control of the defense has already been produced and can be found in the ARCA report, the voir dire testimony, and the trial testimony of Dr. Wolf and Dr. Rentschler. That is specifically in response to request number one. What we have, they have. Mr. Brennan constantly stands up and says, we don't have all the emails, we don't have all the communications, et cetera. They have everything. We've already turned that over.
So he's tripping.
There is nothing that we have not turned over that's in our possession. With regard to the new information that Mr. Brennan says, this is exactly what I was worried about, et cetera, we could not engage these experts until we got permission from the Department of Justice. The federal government had to give us permission. They gave both sides permission on March 26th, 2025. We immediately, Your Honor, as best we could, leapt into action to contact ARCA and engage them formally so that they could act as experts for the defense in this case in furtherance of potential testimony moving forward. We do not have additional testing results. We do not have additional analysis. We do not have additional reports or findings as yet because it's only been a few days. If we get those, we will turn those over immediately. And that's all we can be expected to do. If the court wishes to go through the others, it's listed as 13, but there's actually 12 requests. I'm happy to do that if the court's satisfied with.
I have a question. It was my question last time when they testified. It wasn't clear to me who did what each witness did regarding testing, preparation, things that are normal cross-examination. Is that clarified any better? They said we. They talked about we did this, we did that.
Well, I would disagree with that. Dr. Rentschler talked about what he did, which was more on the biological side.
There was a difference between the
and
two.
Dr. Wolf talked about what he did on the mechanical side. They did discuss what their individual or their specific capacity was and their expertise. We have not received any additional report to that effect. Everything that is in the report is exactly what the Commonwealth received at the same time that the defense received it, and it's exactly what they testified to both in the voir dire and in the trial. There's no clarification, that we haven't asked for clarification. If there is clarification in any new analyses, that will be turned over immediately as well.
Is there anything that they're going to say they cannot provide because of the federal investigation?
Not to my knowledge. I don't know. I haven't asked them if there's communications that Mr. Brennan is asking for that they can't provide. I haven't asked them that because I've not deigned to.
Can we consult with counsel just for a moment?
Sure.
Things their testimony.
Here we go.
I was getting. Right. Ms. Lou I was getting to the point, but she emphasized, and I will emphasize it here, the one thing that the U.S. government has said to both the Commonwealth and to us is in furtherance of their testimony, in furtherance of their engagement, they still are not allowed to detail confidential communications that they had with the U.S. government and the Department of Justice.
But can they testify as to what they did?
Yes. Yes, that is on. That's
Can
on the
they
table.
testify under what direction they did these things?
Well, they can certainly testify to what they did. Absolutely, that is on the table. Every bit of testing, every bit of analysis.
But why they did it?
What their communications were, what their directives were, that is confidential. And
Can I see Counsel at sidebar, please?
So what is the issue here? Because I don't believe the defense is trying to hide something. And Kara Reed, when they, she is involved in all of this. You see, she's not just sitting there. She's not passive. Shout out to her for being involved and knowing what's going on. And respect.
All right, so Mr. Jackson, you're saying that the ACCA witnesses did not do anything, did not read anything, did not consult anything, did not try any additional experiments or come to any findings other than everything that's in that report?
That is correct. That's what we've been told. We have no reason to believe otherwise. Everything that they did, everything they were asked to do, and all the data that they were provided upon which to base their opinions and conclusions is provided in the report, and that was all subject to cross-examination, both at the voir dire and at trial.
All right, and then subsequent to that, information was provided by Mr. Yannetti, and you have that all documented, whatever information the ACCA authorities now are working on is information provided by Mr. Yannetti or his file?
So there's two issues. I want to make sure I don't conflate these. Mr. Brennan mentioned a subpoena that Mr. Yannetti had received at his office.
Mr. Yannetti had brought it up in open court.
Correct. That subpoena was honored, as we had to, obviously, as Mr. Yannetti had to honor it. For every single NOD that we got from the Commonwealth, that was then submitted to the federal authorities.
When was that done?
It was done periodically since the subpoena came into effect.
When did it start?
I don't remember the days. September 1st, 2022.
Thank you.
I didn't remember the specific date, but it was very early on. So the Department of Justice, or the U.S. Attorney's Office, was receiving information pursuant to that subpoena in an ongoing basis. But I want to make clear, that's not information that was then going to ARCA. The U.S. Attorney's Office decided what information, and the FBI decided what information to supply to ARCA to answer their questions.
Do you know what information was provided?
Yes, it's in the report. There were
All right,
14 categories of items that were provided to ARCA, and they said that's all that we were provided.
All right, so then it's accurate to say items that are in the notices of discovery that ARCA does not list were not provided to them?
Correct. That's exactly right.
Okay.
Yeah, they were provided a very narrow, it was a narrow scope of work, if you will, that did not include the myriad things that we were getting in NODs.
All right, then you
September
started
2022.
providing them information to fill in those gaps, right?
Once we received information from Dr. Welcher, for instance, we knew that we wanted at least to explore the idea of rebutting some of that information, from a biomechanic standpoint, and we wanted them to have basically a mirror image of what Dr. Welcher was provided.
All right, so when
that's
did you
what
do?
we provided to them.
When did you do that?
I want to say March 26th or 27th. I think it's in the motion. Just take a quick look.
Okay.
Additional discovery for the experts for their review on March 26, 2025. That same day, the defense was provided all the additional materials to ARCA, including Dr. Welcher's reports and all of his findings, including the 140-page PowerPoint, et cetera. We wanted them to have everything that Dr. Welcher had, as well as Dr. Welcher's reports and findings.
All right, and you say that you will have that, you expect, in the next 3 days or so?
Oh, I didn't say 3 days. I said I think we can count it in days, not weeks. So I would expect if there is something that we're going to receive, it's probably in the next week or 10 days, I would guess.
All right.
We are acting as efficiently as we possibly can, but we can only do so much, given the fact that we were only provided access to hire ARCA on March 26th.
All right, Mr. Brennan, I'll hear you.
Here we go.
This is the very issue I've been concerned about since the beginning of this case. And I've made every effort to alert the court that I had a concern, in fact, that I anticipated this very thing would happen. When I began this case, beginning of October and
He sounds
September,
mad now.
my first analysis was of the past history of this case and dropping experts and information during trial. My attempt was never to preclude ARCA from testifying, never. But it was to preclude the defense from trying this case by ambush. And it was my primary concern, and that is why I filed motions from the beginning of this case. Your Honor must remember, I was filing notices of intention, notices anticipating, things that are not routine because I knew this very thing would happen. We had ARCA witnesses where I still do not believe we have had full disclosure. Regardless of whose fault it is, I still do not believe we have full disclosure. Not just for the basis of opinion, but regarding communications between the defense and ARCA. That's why I filed this motion for discovery. And when the defense responds it's not in their possession of control, that's why these ARCA witnesses who've made representations to this court about not knowing the defense and the limited interaction with the defense, they need to be held accountable. That information should come directly from the ARCA witnesses if the defense can't or won't produce it. I believe there will be information that ARCA has if you order them to bring in all of their communications, email, phone call records, billing, and text messages. And if it exists, I would like to see it. I think I'm entitled. The ARCA witnesses provided a report that blurs the roles of the parties. I can live with that. I can accept that. The ARCA witnesses provide a report that does not have a lot of information about their study and notes. I can accept that because I have prepared for it. But what I haven't prepared for is for the defense to wait until the last minute, then move for a tour request, which they know will take time, then provide information to ARCA on the eve of opening statements.
Well,
and then expect to come in with new opinions and information reports after we've already given an opening statement. It's not only trial by ambush. It not only takes away the Commonwealth's ability and right to prepare, it creates a disadvantage that information and argument is already made to the jury without complete information that they should have had. They could have retained any expert they wanted. They didn't have to wait for ARCA witnesses. They've had 3 years. They could have retained any accident reconstructionist they wanted, but they waited. They moved with a TUI letter on February 7, 2025. Anybody with experience, including the defense, knows it takes time. If they really wanted the ARCA witnesses, they could have moved in November. We gave Judge Welcher's CV in November. We met our discovery deadlines, and they were hard. There was more we would have done or wanted to do, but we couldn't because we honored our obligations to the court and the discovery orders. We provided the discovery pursuant to the orders so that they would be held to the same standard. And now we hear they waited until February 7th, 2025 for a tour request. And now they're giving new information to ARCA to come back and potentially give new opinions that we have no ability for our experts to evaluate. We have no ability for our experts to then go through and conduct more testing. This is the core of preparing for the case. They had that obligation. And so now to allow them to do this, it's not an aberration. This is a continued pattern from the last trial. They have their ARCA
don't talk about the last trial.
That is all pursuant to the discovery deadlines. To now let them change the rules and come in tomorrow, the next day, or 10 days from now and have new opinions after we've already told the jury our theory and our science and not have a chance to rebut it or consider it? I'll have no time during trial to sit down with the experts and assign them to review new information, new reports. I'll have no time to go back and reconsider the order of witnesses or the information we need or witnesses that we've decided we don't need in this case in scheduling.
And that's fair.
If it wasn't so obvious this was going to happen, I wouldn't be so upset about it. At some point, the defense has to be held to the same standard of discovery obligation. This isn't late notice. This isn't parachuting in. This is an effort they decided to make and wait until February 7, 2025.
Has the prosecution had any issues with late discovery? A lot of y'all have been following this trial for a long time. Has the prosecution been pretty on point when it comes to late discovery, or do we have a little bit of the pot calling the kettle black? Let me know.
Your Honor, I ask you to allow ARCA to testify, allow them to testify to their report, be confined to the report that has met discovery deadline,
I figured
and
they
to
were
produce the request that the court ordered regarding discovery of the information that we want. That's what I asked this court to do.
Your Honor, what appears to be feigned indignation is just not consistent with the facts. We didn't receive Judd Welcher's report until basically February 2025. We received a report, I think it was January 31st, 2025, and we read it for the first time the next day on February 1st. Nobody's been dragging their feet. There is no ambush. This feigned indignation is just not consistent with the facts, Your Honor. The court hadn't ruled that we could even use ARCA until just a few weeks ago. We've been moving expeditiously to try to rebut a witness that the Commonwealth disclosed in February of 2025. By mid-March, we asked for a TUI request. We asked for a TUI permission, or asked permission to engage them through a TUI request. That does take time. We did it expeditiously. We weren't waiting for some advantage. As soon as we got the request approved, we immediately, that day,
Yeah, that's what he's saying here.
and immediately that same day, provided the Commonwealth notice that we had engaged them and we intend to use them to, at the very least, to address Judd Welcher's testimony or his reports, the last iteration of which we got on March 24th. So if you want to talk about dates and chronology, what's good for the goose should be equally good for the gander. Mr. Brennan has been consistently providing us with new discovery after his certificate of compliance has been well done, the ink is well dry. We have a right, we have an obligation to address and to meet his new discovery. For instance, Judd Welcher's opinions and conclusions, with rebuttal opinions and conclusions, if we can. And I want to make sure that we're not conflating two separate issues. One is the information that ARCA had outside of any of our control. Nobody in this courtroom could have reasonably controlled what information they had.
But you did say that's all listed in the report and there's nothing more.
I was just about to say, the communications that they had with U.S. Attorney's Office, I don't have any access to that. That's confidential. But I do know what they provided to them for their analysis. That is all listed in the report. And both sides have had that from the day we received the reports, the federal disclosures. Both sides have had those. So nobody was in any disadvantage in the first trial, and certainly nobody is at a disadvantage in this trial. We're simply trying to meet our obligations as we could within the confines of the rules that were set up in no small part by the federal government. And now those strictures have largely been lifted. And we're moving forward as expeditiously as we possibly can.
Rather than addressing their obligations, it's always an attempt to assign blame. The government or the Commonwealth gave us late disclosures. The changes in Judd Welcher's PowerPoint were by exclusion. Attorney Alisi had concerns about certain things in the report, so we took things out of the report. There's a difference.
So you first provided it in November, then you're saying?
No, we provided, pardon me, we provided his CV in November, and then we provided on our discovery deadlines January 31st, 2025, And then on February 5th, we provided all of the detailed background notes, references. And so we met our discovery deadlines. The changes to Mr. Welch's report have been the complaints, understandably, about what they believed was hearsay or inadmissible. So we removed pieces. There was no new testing. There was no new reports with information changing any of the things.
According to Mr. Alessi, who is much more facile with the facts of what's in Judge Welch's report, that's not quite true. There were additions made to the latest iteration of his report. And Mr. Brennan just admitted that February 5th was the first time that we received all of the information from Judge Welcher.
Yeah.
The next month, within a few
Stop
weeks
complaining,
of that,
man. It's just a part of the
That's when we
game.
received permission to hire ARCA. That's when we received permission to engage ARCA. That's when we provided the individuals at ARCA with everything that we had been provided just the month earlier. So there's no ambush. There's no attempt at taking an advantage vis-a-vis time. It just doesn't, the arguments just don't play, not with the facts and the chronology of what we've been doing and we're continuing to do.
All right.
Yeah, I don't think they have a case here. Come on, Mr. Brennan. You're better than that.
Is the only thing left the motion to sequester Aidan Kearney to remove him from the sequestration order? Is that the only thing that's now left outstanding?
No, Your Honor. There's also a motion in limine that was outstanding. It's the Commonwealth's motion in limine to prohibit reference to any pending internal affairs investigations.
Yes, where do we stand with that? I thought that you were going to...
We've had a chance to review the file. If there's any statements that are relevant, we think the defense is entitled to use those statements for impeachment or cross-examination. As far as the rulings,
Shouldn't be a big deal.
Administrative body's rulings, that should not be permissible. It's an opinion of a third party, and then it will open the door to the explanation that those sustained findings are limited to certain conduct, but don't include other types of conduct which we would need to rebut. A third party's opinions are not admissible to impeach a witness.
The defense vehemently disagrees with that assertion. That's not the state of the law. We did provide notice to the Commonwealth of what we intended to admit at trial. The Commonwealth was conversely ordered to provide notice to the defense of what they were specifically asking to keep out. That was supposed to be done 2 weeks ago. I emailed Mr. Brennan the next day after it was due. They did not respond. I was told this morning they're seeking to exclude everything. I would like to be heard on that, Your Honor.
All right, so I don't have a copy of what it is you intend to introduce, right?
No, we provided notice to the Commonwealth, but
So I need that. Do you have it?
I can articulate to the court. We want to admit the sustained findings that have been made against 4 separate officers in this case.
You know what? I do need that in writing. I need this in writing. I need a Commonwealth's response.
We needed to have a ruling on this in advance of.
Excuse me?
We need to have a ruling on this in advance of Monday.
Right.
I can try to get that to you today.
All right, get it to me today. I'll decide it tomorrow.
Okay. Are we allowed to make an oral argument as to this issue? It has been briefed already by the Commonwealth.
Okay. You know, what I need is, I wasn't expecting this here today, so what I need is the paper number. I think it's the Commonwealth's motion to exclude, but the last I had it as it wasn't under advisement. You were going to figure out what the objection was and what you wanted to put in. All right, so we need to take a recess anyway so that you can look at the video to see whether there's an objection to the opening. So why don't we take a 15-minute recess? And Ms. Little, if you can provide just the paper number and what the Commonwealth's response was.
It's paper number 588.
All right.
All right, there it is. So interesting. I love how they're laying everything out and making it make sense when it comes to what's going on with these different motions. They're doing an excellent job of explaining it because, as I said, we just started following this recently, and it's all starting to play out what the defense is trying to prove, what they're trying to do, how they're trying to use certain reports. And it seems like there's a little pettiness going back and forth here, but this is going to be an interesting one. Trial starts, opening statements start on Tuesday. Y'all know we're going to be here covering the whole thing. Looking forward to it. Let me know what you'll think about this in the comments and in the chat. Speaking of the chat, shout out to the chat gang, man. Y'all in here showing major love. My guy, Dr. EJ, is showing up with his 1-month membership milestone. Shout out to Dr. EJ. He also gifted not only 1, but 5 memberships. So he gifted 6 memberships total. If you got a membership from Dr. EJ, make sure you say thank you. He's always in here, always showing love and support and doing some great work as well. Appreciate you, Dr. EJ. We've got CPE in here, gifted 5 memberships too. Oh my goodness. If you got a membership from CPE, make sure you say thank you. Y'all also go check out the members only content that we have over there too. Some great interviews, some great conversations over on the members only side. So y'all don't want to miss out on that. Thank you, CPE. And we've got Kara Hampton in here. Says, does Judge Bev know what she's doing? Is she even paying attention? Yeah, I think I was with her on this. I was a little confused about the point the defense was trying to make when they were saying there were certain reports and they had this report that was already given, but they were missing certain parts of it and they hadn't received it. And then they clarified and said, and they clarified the timeline. So I could kind of see where she was getting confused there because they had me lost for a minute too. All right. And then we got Les Cleaver in here. He just dropped a 5 bomb and said, I pray each of you have a great weekend. Always be loved, always be blessed. And above all, be safe and have fun with those you love. Happy Easter weekend to you, Les Cleaver, as well. Hopefully you get to spend some time with your family and friends as well. Nosy Rosie says the argument is that the prosecution does not want the defense to bring in that MSP found that Proctor was biased and that's why he was fired. Oh, interesting. Okay, I'm sure we're going to hear more from them later. I had another interview that I wanted to cover. I said we were going to talk about what's going on with Turtle Boy, Aiden Kearney, with him pleading the 5th, but we might get into that on Monday. Let's see, how long is this video? 9 minutes? We're going to talk about, I'm going to save this one till Monday. All right, we'll cover that on Monday for y'all. Thank you again to everybody who's been in here and supporting. Thank y'all for another amazing week. We are going to be live tonight, so if y'all want to check out some music from the artists in the community, make sure you do that. Also, if you could do me a favor, make sure you like the video on your way out. Thank you for getting us to 100% likes. Y'all do not know how much that helps out the channel and continue to grow. Hope you guys have a great Easter weekend. Enjoy the time with your family and friends. And as always, you know what to do. Keep growing, keep pushing, keep it classy. We gone. Peace.